I would like to welcome everybody. My name is Udvarhelyi from the University of Miskolc, and I also would like to greet everybody on behalf of my Hungarian colleagues, Professor Dr. Judit Jacsó and Dr. Ferenc Sánta, who are not able to participate in the conference due to other commitments, but they are sending their warm regards to all the participants of the conference, and hereby I am representing our little Hungarian team during this presentation. The title of the presentation is some reflections on the border barriers and their legal protection, with particular emphasis on the Hungarian regulation. In this presentation, I will mostly focus on the Hungarian criminal protection of the so-called border barrier. The starting point of my lecture is the so-called technical or physical border barrier, or simply the fence, which was erected on the southern border of the country of Hungary as an answer to the migration wave that hit Hungary in 2015. In its response, the Hungarian government formulated a package of measures consisting of several points. The first step was the construction of the temporary security border. This was the physical border barrier. And the second was the adoption of Act 140 of 2015, which created the legal background of the management of mass immigration, which is called in the literature the legal border barrier. This act criminalized new forms of illegal immigrant smuggling, increased the applicable penalties and sanctions for this crime, and changed the sanctions system in the Hungarian criminal law significantly. Furthermore, which is the most important for our topic, it introduced 3 new criminal offenses into the Hungarian criminal law. These are the so-called crimes against the border barrier, namely the unlawful crossing the border barrier, the damaging the border barrier, and the obstruction on construction work of the border barrier. In the lecture, I will speak about these criminal offenses briefly. Before examining the factual elements of the criminal offenses, it is useful to place them in the system of the criminal code. These criminal offenses are defined by the Hungarian legislator in Chapter 34, titled Crimes Against the Order of Public Administration. The order of the public administration as a protected legal interest means the social interest for the proper functioning of the public administration in a broader sense. In a narrower sense, these criminal offenses aims at the protection of the state border and the lawful crossing of the state border as a part of public order and public security. Now I want to turn to the dogmatic analysis of the 3 criminal offenses. Here you see in the slide the first criminal offense, unlawful crossing the border barrier. This criminal offense is basically a special case of the illegal crossing of the Hungarian state border. Generally, illegal border crossing, which means the crossing of the state border without authorization or in an unauthorized manner, is now an infraction, administrative offense, which is punishable by a fine. However, if someone unlawfully enters the territory of Hungary on a border section where the facility for the protection of the border has been constructed, it is a criminal offense. It means, therefore, if somebody crosses, for example, the Hungarian-Romanian border or the Hungarian-Ukrainian border, it's an infraction. But if someone crosses the Hungarian-Serbian border through the border barrier, it's a criminal offense. It can therefore be seen that only entering unlawfully the territory of Hungary across the facility installed for the protection of state border is punishable. Unfortunately, this concept is not clearly defined by the criminal code. According to the legal literature, this can only be an artificial fixed or mobile facility built or installed specifically for the purpose of border protection. Examples are fences, cordons, mobile containers, wire barriers, and fixed or mobile checkpoints. In practice, the crime is committed by entering the country after, for example, cutting or breaking down the fence, climbing over the fence, entering, crawling under the rapid deployment barrier, or entering through the fence damaged by another person. However, the unlawful entry by circumventing the border barrier or flying over the barrier in an aircraft is not a criminal offense. Technically, the perpetrator of this offense can be anybody. However, according to the criminal statistics, most of the perpetrator of the crime has Afghan, Iraqi, Syrian, Pakistani, or Iranian nationality. The crime can be committed intentionally, and it is completed when the perpetrator enters the area protected by the border barrier. The aggravated case of the criminal offense is when the offense was committed with weapons, by other deadly instrument, or as a participant in a crowd disturbance. The most serious form of the crime is when the aggravated offense causes death. In this case, the death of the victim can only be caused by negligence, otherwise intentional homicide must be established. Finally, in the side we can see some statistical data in connection with this criminal offense, which shows that after the installation of the border barrier, the authorities had to take action very often due to unlawful crossing the border barriers. But following the change of the migration routes in the Balkans in 2017, the number of offenses decreased dramatically. Now, the second criminal offense is damaging the border barrier, which can be committed by a person who destroys or damages a facility or device installed for the protection of the state border. The punishable conduct of the crime is the damaging or destroying the object, for example, cutting through the border fence with wire cutters or knocking down the said marker. The extent of the damage caused by the crime is not relevant. It should be noted that this criminal offense is a so-called subsidiary statutory definition, which means that it only can be established if the act doesn't constitute a more serious crime. In the relevant literature, the question arises as to which would be a more serious offense in practice, which would replace this criminal offense, taking into account the fact that even the single case of the crime is punishable by imprisonment from 1 to 5 years. In practice, and according to the majority of the literature, damaging the border barrier and unlawful crossing of the border barrier cannot be established cumulatively. If the offender damages the border barrier and then enters Hungary, he or she can only held liable for the more serious criminal offense of damaging the border barrier. In practice, the question also arises whether the damaging the border barrier and the illegal immigrant smuggling can be established cumulatively. But since one of the aggravated cases of the illegal immigrant smuggling is that this criminal offense is committed by destroying or damaging a facility installed for the protection of the state border, it means that only this aggravated case has to be established. You can see some statistical numbers in connection with this criminal offense as well. The data show that this crime was also frequently committed after the border barrier was installed. However, it also shows a decrease following the change of the migration routes, but not to the same extent as the previous criminal offense. And finally, the third offense is the obstruction of the construction works of the border barrier, with which the legislator intended to provide criminal law protection not only for the system already in place, but also for the construction and maintenance work related to it. The criminal offense is also a so-called subsidiary offense. It cannot be established if the offender's conduct also falls within the scope of another criminal offense. The punishable conduct of the crime is the obstruction of the construction or maintenance of the facility installed for the protection of the state border. Examples of the conducts can be seen in the slide. Similar to the previous two crimes, the perpetrator can be anybody, and it only can be committed intentionally. It should be emphasized that this crime is an immaterial offense. Result is not necessary for its completion, since the relevant provision doesn't speak of stopping, but of obstructing the works. If we look at the numbers, we can see that no criminal proceedings have been initiated for this crime since its introduction. This may be explained by the subsidiary nature of the criminal offense. Finally, I would like to try to answer the question whether the criminalization of these crimes is consistent with the ultima ratio principle and whether the creation of this criminal offense was necessary at all. The reason for this is that the introduction of these offenses has been criticized heavily by the domestic criminal literature. It's true and obvious, of course, that the state border need to be protected even with the means of border barriers or fences. The question is whether its criminal protection is necessary or not. In connection with the unlawful crossing of the border barrier, according to our point of view, imposing criminal sanctions for this offense can only be justified in cases where it is committed on a massive scale, uncontrolled, or by violence against a person. The Hungarian government has set up a physical border barrier to prevent such acts, which performs this function adequately and effectively. It's therefore worth considering the decriminalization of this crime and at the same time the amendment of the Act on Infractions to provide the use of detention as an infraction punishment and expulsion as a separate infraction measure in case of illegal border crossing. This solution will be more consistent with the ultima ratio nature of criminal law. In connection with the second criminal offense damaging the border barrier, the legislator clearly established an exaggerated sanction which is neither proportionate to the gravity of the conduct nor to the punishment of other similar offenses in the criminal code. This criminal offense is therefore not necessary in our legal system because there is a similar offense, namely the criminal damage, which existed and still exists in the Hungarian criminal law. Therefore, it could have been a better solution if the legislator had introduced a new aggravated case of this offense instead of creating a bare new one. And finally, the legitimacy of the third criminal offense, the obstruction of the construction work on the border barrier, is also questionable for several reasons. Firstly, the construction of the border barrier has been completed, so this crime cannot be committed at all unless the government decides to build a new border barrier. Secondly, the substantive gravity of the crime is not proportionate to the potential imprisonment. Administrative fine would be sufficient in this case. Finally, the statistics also show that this crime is not committed in practice at all. Therefore, we consider that this act could be placed either in the system of administrative criminal law or infringement law subject to administrative fines. Summarizing the opinions in the legal literature, it can be said that the border barrier in itself has a deterrent effect on the irregular migrants. There is no need to criminalize acts related to the border barriers because the physical border barrier and the effective police measures alone can deter and prevent irregular migrants from entering the territory of Hungary illegally. However, we are rather skeptical about the proposed decriminalization because these crimes are so-called symbolic criminal offenses which once enter the criminal law system are very difficult to eradicate because of the symbolic nature of these norms is reflected in the fact that they become punishable expressing the social disapproval of these behaviors. Thank you very much for the attention.